A grandmother walked into my office last week with a 10-year-old granddaughter at home, a 3,000 square foot house that she had just built for retirement, and an out-of-state will that a family friend drafted for her and told her was enough. In the next few minutes, I'm going to tell you exactly what's wrong with that will, why it can't protect a grandchild in North Carolina, and the 3 planning moves that grandparents in this position have to make before anything else. If you get this wrong, your grandchild gets a lump sum at 18, all of your assets go through probate in 2 states, and the court decides who's going to raise your granddaughter and not you. A will is often the wrong planning tool for a minor because it just doesn't control everything in the right way. Multiple states of real estate, multiple financial assets with beneficiary designations means that we have a complicated probate process in multiple states with beneficiary designations naming this grandchild directly. Minors are not allowed to own property in North Carolina or in any state because they are incompetent by virtue of their minority. So they're not allowed to receive and own and control assets until they're 18. Even if the accounts are held in a Uniform Transfers to Minors Act or UTMA account for the minor gets full ownership at least 21. Even a will with the most robust provisions about delayed gratification to later ages and whatnot are not going to control assets that the will itself does not control. Beneficiary designations, assets in a trust, other assets in someone else's name or payable to somebody else's benefit are not going to be controlled by your will. And so even including those types of provisions are not going to be helpful for those types of assets. When a grandparent is part of a blended family and they have stepchildren from their second marriage and now a grandchild that is wholly reliant on them, we can end up in an unfortunate and inadvertent shifting of resources after the grandparent passes away. Leaving everything to your surviving spouse can mean that that spouse redirects the flow of that assets away from your grandchild and to their own children, your stepkids. And a will does nothing to prevent that. Beneficiary designations, outright bequests to your spouse mean that they own everything and don't have to adhere to what the goal was when we were all talking this through before you passed away. And when we pass away in North Carolina with a North Carolina will or an out-of-state will that we brought with us to North Carolina, we're unlocking multiple probates. If we have real estate where we came from and the home we now live in, our will must be probated in each of the counties where that real estate's located. So not just one probate, but multiple probates, depending on where and how many assets you have. If you're a grandparent raising a grandchild in North Carolina and you haven't updated your estate plan in at least the last 12 months, the link in the description below gets you on our calendar. Guardianship is not the same as inheritance. The person who raises a child doesn't necessarily have control over the assets for that child. And quite frankly, the person who raises the child may not be fit to manage the money for that child. Most grandparents are only thinking about that first role and not the second. But it's not enough to just appoint one person, because what if they're not available or if they predecease you and you didn't update your plan accordingly? We need to build out a successor bench, multiple guardians, multiple trustees. If you find yourself with a very short bench of potential candidates in your life, you can always rely on a professional to be your trustee instead. Firms like Cary Estate Planning serve as trustee for their clients all the time when they don't have other great options. Estate planning for grandparents raising their grandchildren is one of the most overlooked aspects of estate planning in North Carolina. If you're in this position, the consult link below is the easiest way to figure out what your current plan would actually do. If you know someone in this position, you should send them this video. Probate, taxes, and creditors are preventable. Schedule your consultation with Cary Estate Planning now.